A brief introduction to contract drafting. To understand contract drafting, you should recognize that it involves two aspects that together make up every contract. First, there are the organizational parts of a contract. And second, there are the contractual concepts, which are the different operative elements within the contract. Organizational parts. Like most legal documents, all contracts follow a basic format. The style of a contract may vary widely from one law office to another, and the length and detail of a contract will vary greatly depending on how complicated the transaction is. But every contract contains at least some of the common contract parts. They are the frame of the contract, which is the formal language at the beginning and signatures at the end. A definitions section, which are the definitions used in the contract. The business sections, which set out the parties' rights and responsibilities. The termination section, which deals with the end of the parties' relationship.
The general provisions section,
sometimes called the boilerplate, which contains statements of policy that govern the contract. The contractual concepts. The parts of a contract make up the organization of the contract, but the contractual concepts consist of the operative language in a contract. These are the words that create contractual rights and obligations, are the basis for contractual liability or authority, and set out policies for regulating the contractual relationship. An easy way to think about the concepts is to associate them with verbs or actions. Just as every sentence must have a verb, every sentence in a contract contains at least one of these concepts. They are declarations. A declaration sets policy for the contractual relationship. For example, a drafter could use a declaration to define a term, or say to provide that New York law governs this agreement. A declaration does not create any obligation or liability.
A declaration is signaled by the present tense of the verb. The purchase price is $25,000 is an example of a declaration.
Now note that it does not obligate the purchaser to pay the purchase price. To do that, the drafter would use a covenant. A covenant obligates a party to do or to refrain from doing something. It also creates a right to the obligated party's performance belonging to the other party. So in other words, a covenant is a contractual promise. A covenant is signaled by the use of shall. Buyer shall pay the purchase price is an example of a covenant. Covenants are one of the three contractual concepts that are routinely studied in first-year contracts classes, the other two being representations and conditions, as discussed later. First-year law students read a number of cases construing and interpreting promissory language, that is, language creating a covenant. Now, it should be noted that the use of shall to signal a covenant is not subject to universal agreement. In some firms, a covenant is signaled by the use of will. In other firms, both shall and will, and sometimes must, are used interchangeably. Best practice, however, is to use shall, because unlike will or must, it unambiguously signals an obligation. Conversely, will can be used to indicate futurity, as in, the landlord shall pay for repainting the leased premises, but the tenant may choose the color that the painter will use. In that sentence, will does not create any obligation on the part of the landlord or the tenant, and the painter is not a party to the lease agreement between them, and so cannot be obligated under it. It merely indicates something that is going to occur in the future. Similarly, as discussed in the text, must can be used to signal a condition rather than a covenant. So, to avoid ambiguity, which is a central goal of contract drafting, it is best to use shall when drafting a covenant. Now, technically, representations and warranties are not synonyms, Briefly, a representation can only be made with regard to past or present facts. The verb must be in the past or present tense. A warranty is a promise that a fact, usually regarding the condition of something, is true. Unlike representations, warranties can extend into the future. So, for example, seller warrants that the product is free of defects for a period of 1 year from purchase. The remedies for each also differ in some respects. However, for our purposes, the difference between them is not crucial. Together, they can create liability on the part of the party making them if a fact is not as represented and warranted. For example, if an employee represents and warrants that she has earned a JD from State University, and this is untrue, the employee could be liable in damages for misrepresentation and breach of warranty, or the false representation could result in a rescission of the contract. First-year contract students typically study cases where one party is alleged to have misrepresented a fact and the other party is seeking damages or rescission. A grant of discretionary authority gives a party the discretion to do or refrain from doing something, but does not obligate the party to do anything. A grant of discretionary authority is signaled by the use of may. So, for example, in this sentence, the landlord shall pay for repainting the leased premises, but the tenant may choose the color that the painter will use. The use of shall indicates the landlord is obligated to pay. It creates a covenant, while the use of may indicates that the tenant has the discretion to choose the color of the paint. It creates a discretionary authority. A condition is an event not certain to occur, which must occur before performance under a contract becomes due. This is in the Restatement of Contracts Second, Section 224. Conditions are studied in first-year contracts classes, both express conditions, which are set out in the parties' agreement, and implied conditions, which are read into the agreement by the court. As contract drafters, we are only concerned with express conditions. Of all the contract concepts, conditions are probably the trickiest to master, for at least 4 reasons. So first of all, they never occur in isolation. A condition is always attached to an obligation, either a specific covenant or the contract as a whole, a grant of discretionary authority, or a declaration. Second, unlike the other contract concepts, the language signaling a condition can vary from contract to contract, and even within a single contract. Third, the common law is not fond of conditions, and in cases of ambiguity, a judge often prefers to interpret the provision as creating a covenant instead of a condition. And finally, the failure of a condition does not, in and of itself, create any liability or right to damages. That is, a condition is never breached. It is either satisfied or it fails. The condition might trigger an obligation, but it did not create the obligation. Some other contract language did that. Similarly, the failure of a condition may have unpleasant consequences, such as allowing one party to terminate the contract, but there will never be a right to damages because the condition failed to occur, unless a party also promised that the conditional event would occur, but that promise would have to be found in separate language creating a covenant. A condition can be signaled by the use of phrases such as if, provided that, in the event of, unless, or it is a condition of, as well as by the use of the verb must. A common example of an obligation subject to a condition is found in many real estate purchase contracts, where the buyer's obligation to close on the purchase of the home is conditioned on the buyer obtaining financing. Obtaining financing is the event not certain to occur, which must occur before the buyer becomes obligated to purchase. So let's look at an example of discretionary authority subject to a condition. If the tenant fails to pay the rent on or before the 10th day of each calendar month, the landlord may impose a $25 late fee. Now here, the tenant's late payment is the event not certain to occur, which must occur before the landlord can exercise its discretionary authority to impose a late fee. Now note that the landlord is not obligated to impose a late fee. It may or may not do so at its discretion. Moreover, assuming the lease also obligated the tenant to pay the rent on time, for example, it also included the provision, the tenant shall pay the rent on or before the 10th day of each calendar month, the late payment would be both the condition triggering the landlord's discretionary authority to impose a late fee and a breach of the tenant's promise or covenant, which would give the landlord a separate right to damages. Typically, the damages would be the unpaid rent plus interest. As stated previously, every provision in a contract falls into one of the previous categories of contract concepts, depending on what the provision seeks to accomplish. So, a definition or statement of policy is a declaration. An obligation or promise to do something is a covenant. A fact to be relied upon is a representation and a warranty. An option to do something is discretionary authority, and a triggering event is a condition.